Welcome to the Citizens Band Radio Hour. Thoughtful conversations that explore issues of media and journalism, democracy and citizenship. The Citizens Band Radio Hour is sponsored by the Center for Media and Citizenship at the University of Virginia. You can visit the center online at mediaandcitizenship.org. Here's your host, Coy Barefoot.
Claire Gastanaga is the executive director of the ACLU of Virginia, and she joins me live on the program. Claire, it's been a while. Thank you so much for making some time for us. I've been looking forward to talking with you. Claire, let's talk about August 11th and 12th in Charlottesville. Before we talk about your reaction to some of the reviews that have come out, Tim Hafey's report, the review by the state, before we talk about the ACLU's involvement early on in this, in the events of August 12th and the Unite the Right rally, generally speaking, what are some of the key takeaways for you as you look back on this tragically historic event here in Charlottesville?
Well, I mean, obviously there are a lot of takeaways. Anybody who has any feeling at all was devastated by what happened that weekend, and that was certainly true of all of us here at the ACLU of Virginia. But, you know, we have a role to play here, and the role is to make sure that government complies with the Constitution. We don't make the permit rules. We don't issue the permits. We don't make the law. We don't make the judicial decisions. But what we do is ensure that everyone is entitled to a government that operates in accordance with constitutional standards.
Tell us about the involvement of the ACLU early on when the city of Charlottesville, and as we learned late in the game, tried to change the location of the Unite the Right rally. They tried to move it to from the park downtown, formerly Lee Park, to McIntyre Park. Yeah,
I mean, you're constructing the scenario a little bit differently than I would. I mean, for me, a lot of this started in July during the Ku Klux Klan rally, where the police did what police are supposed to do. They set up a perimeter. They kept the two sides apart. They escorted the unpopular speaker in and out of the city. And then, of course, they proceeded to act in a way that was not, we believe, consistent with the best interests of the public or the Constitution. And we joined the Legal Aid Justice Center, the Rutherford Institute, and the National Lawyers Guild in writing a letter that was very critical of the way the police responded to counter-demonstrators after the Ku Klux Klan, had left the building, if you will. And they engaged in action that we thought was we didn't think they had the legal grounds to declare an unlawful assembly, and we believe that they used tear gas in a way and at a time that demonstrated an excessive use of force under the circumstances. We think if they had just stood back, the counter-demonstrators would eventually have left, and that their, aggressive efforts to disperse the crowd were unwarranted under the circumstances, and we wrote a long letter to that effect. We were present at a July 19th council meeting at which many people asked for the August 12th permit to be revoked. We presented through our spokesperson at the time, who was the executive director of the Legal Aid Justice Center, Mary Bauer, our concerns about what happened on July 8th, and certainly asked the council to be aware, and the city manager and the police chief to be aware of our concerns about the way that was handled. Fast forward to, the 4 days before the event that was scheduled for August 12th, the city's permitting process issued a permit to Mr. Kessler by operation of law, because they had an ordinance that said that when he applied on May 30th, his permit was automatically granted on June 12th, since he hadn't heard anything different. And we had heard some rumors that they were going to try to take an action with respect to the permit, and we wrote the city and said, along with the Rutherford Institute, hey, if you're going to try to engage in a prior restraint here, you need to meet some constitutional requirements, among them due process. And, we'd like to know by a date certain that you're going to do that. And this was written on Monday, and we gave them till Wednesday. And I called the city attorney and said, what are you guys going to do? And can we work this out? And can we get you guys to do the right thing and engage in due process and all the other things? And they said no. And Kessler approached us like at 2:00 in the morning Monday night after they told him they were revoking his permit and reissuing it. And we made a decision to go ahead and file a lawsuit to hold the city to the constitutional standards that apply to everyone, that, when they've issued a permit, in order to engage in prior restraint, they have to go through a process, and part of the process is affording the permittee due process, and part of the process is showing a court that there is concrete evidence of a threat of violence in order to engage in a prior restraint on speech. And the city came to the court, and I think this is clear from some of what was said about the way the chief of police approached the court proceeding. And came to the court and basically said there are going to be too many people. They never put any evidence on with respect to safety or concern about violence. And the court said, well, if it's numerosity that's your problem, why haven't you suspended the permits for the expected 2,000 counter-demonstrators who have 2 valid permits that you have not withdrawn? And the city couldn't answer that. And so the court said, given the facts before me, I have no choice but to say you can't, you have to go forward with the permit you've already granted.
And Claire, let me just underscore that for a second, because I think that's a critical point that a lot of people who have been following this story, that they're literally not aware of, that in trying to move the rally, the Unite the Right rally, to McIntyre Park, the city never once made the argument, we are afraid of violence. We think that this is going to be violent, and it'll be easier to keep the violence at a minimum and keep these groups apart in a bigger park. They never once made that argument ahead of time.
No, they did not make that argument before the federal court. They kept saying that they were concerned about numbers of people, and the issue there was they have far more people who've shown up in the past for things like gay pride and some community events than the 1,000 that they were projecting that would show up who were Nazis. And they were the affidavit the chief put before the judge said, I'm expecting 1,000 Nazis and 2,000 counter-demonstrators. And look, the reality is what the police did on July 8th, they didn't do on August 12th. They didn't keep the two sides separate. They made no effort to do so. They didn't construct the space in a way that would do so. They didn't make plans to escort the offensive speakers in and out of town, which, public safety might have suggested they should do. And they failed in their obligation. I think the most salient comment made in the Heafy report was they failed in their obligation both to protect public safety and to protect free speech. And, there are 4 days. We made decisions in a very tight time frame, and the only decision we made was to assure that everyone has their constitutional rights protected. And that is true of everybody. I mean, we would do the same thing for the counter-protester group. In fact, we raised serious questions about the way they were treated on July 8th. And we still haven't gotten those completely resolved in a way that, to our satisfaction. We do believe that the chief, I was there on August 12th on the ground in Charlottesville, and the thing that rang true for me in the report was the chief saying that he suggested to people to let people fight because it would be easier to declare an unlawful assembly. We criticized him on July 8th for the declaring an unlawful assembly when we didn't think he had grounds. And so it doesn't seem out of the context to me that he would say, well, okay, I'm gonna wait till, I'm going to let them fight. Anyway, look, there's so many other people who are looking at this very carefully from an expert eye and making decisions about what should happen. We want to be a constructive part of the discussion about how we go forward to make sure this never happens again. And we've already made a presentation to the Virginia Municipal League on the principles that we think should guide decision-making about permitting processes, and we'll be commenting on the governor's emergency rules that he put out on the Lee Monument, and we are issuing a white paper that discusses the law with respect to permitting and documents the principles that we think should apply, because we want to help localities make these decisions in a way that's constitutional. There's an old case involving Arlington County where the Nazis wanted to meet at a school, and the courts have pretty much laid out without that any person could understand the process that government needs to follow if they want to engage in the prior restraint of speech. And that involves showing that there's concrete evidence that there's a real threat of violence, and giving the people who want the permit due process in when and if the government decides either not to issue a permit or to revoke one that's already been granted.
Claire Gastanaga is the executive director of the ACLU of Virginia. You can find them online, acluva.org. Claire, I know there was some public conversation and an announcement by the National ACLU in the wake of Charlottesville. There was a bit of a review after the fact that the ACLU considered, right?
Well, listen, the ACLU said in the 30s, when the Nazis were marching, that we didn't have any obligation to represent anybody who wanted to parade with arms, and obviously the Constitution guarantees the right to peaceably assemble, not the right to violent assembly. And in this case, this particular case, we made the permit applicant, Mr. Kessler, sign a verified complaint. That's a complaint that is under oath, and lying is a federal crime of perjury. We made him sign something saying that he fully expected and intended for the August 12th event to be nonviolent. And he signed that. He signed it under oath, and he signed it under penalty of perjury under federal law. And, that is an important thing that a lot of people aren't aware of. And in terms of the national ACLU and the Virginia ACLU, we're an affiliate of theirs. We have a process by which policy is developed for the national that involves all of the affiliates. I know the executive director was interviewed by the Wall Street Journal, and he said some things. But we've done our own after-action review. We've obviously, shared really serious concerns about our failings in terms of our communication with important stakeholders before the fact about what we were doing and why, and we also reevaluated the strategic criteria we use to make decisions about which cases we take on, to ensure that we're very conscious about the importance of interacting with our allies and our stakeholders in our work when we are confronting things that are controversial. No one can look back on August 11th and 12th and feel good about what happened, and we don't. And it's something that we will continue to think about as we move forward.
Claire, let me back up for a minute, because you just said something that I was not aware of. And as you just said, I bet most people aren't aware of this, that Jason Kessler signed a federal affidavit under oath attesting to his belief and assuring the ACLU that the events of that weekend would be nonviolent. And if there's any evidence that he knowingly perjured, he could face charges for that, correct?
Yeah, he signed what's called a verified complaint, and not every complaint in a court that's filed in a federal court is verified, but we took that extra step. And what that means is that you ask your client to sign look at the facts that you've pled in the complaint, and one of the facts was that this was intended to be a nonviolent event, to look at all the facts in the complaint and to sign something swearing under oath, under penalty of perjury under federal law, that everything that's said in the complaint in terms of factual representations is true. And we went the extra step of having Mr. Kessler verify the complaint because we wanted to be sure that that he was making that representation in good faith. And so, obviously if he lied on the verified complaint, that lie is subject to sanction as perjury.
And do we expect that to happen?
Well, we're not the prosecutors. So, it's out there. It's, It would be up to the U.S. Attorney for the Western District as to whether he wishes to make a case out of that.
Because this was in a federal court.
Yeah. I mean, it would be the U.S. Attorney because it's federal court and it's a federal complaint. And it is one of those things where, we went the extra step and asked our client to do that, and he did it, and we assumed that anybody who would sign something under penalty of perjury was telling us the truth.
So the use of weapons or the brandishing of deadly weapons or weapons of force at a free speech event, that really has thrown so many people for a loop as they try to make sense and wrap their minds around what happened on August 12th, that there is the ideal of free speech, but then there is something, there's a line that's crossed when the people that show up for free speech bring deadly weapons to the event.
Yeah, I know. I mean, I think we're all of one mind that some kind of regulation of weapons, whether they're guns or sticks or other kinds of weapons, that regulation of weapons at a public protest is a reasonable time, place, manner rule, and that it isn't a constitutional question. In Virginia, it's a state law question, and there's not a constitutional impediment to any government agency making a decision that in express circumstances of public assembly that people aren't going to be allowed to come with weapons. People do that in public assembly all the time, whether it's concerts or political conventions, when they say you can't put your sign on a stick. I mean, that's a rule at the state capitol. You can't bring a sign in with a stick because it could be used as a weapon. And that's a reasonable time, place, manner rule. Nobody thinks that's a constitutional concern, certainly not us. But it is a state law problem because there is a statute that the General Assembly passed that I think it was Delegate Linghamfelter, now soon to be former Delegate Linghamfelter, sponsored, that basically took away from the localities any authority to regulate guns at all, anywhere, anytime, any place, for any reason. I mean, I remember the conversation about that bill, and it wasn't. One of the things people talked about all the time was that they wanted to be sure that people couldn't be banned from bringing their guns to a shelter if they were all in the Coliseum after, a hurricane or something. So, it was a fairly extreme bill at the time, but it takes away the authority from the localities to make decisions that are in the public interest. And, I'm sure that there are going to be bills this session that would seek to give the localities that authority. Certainly the governor has chosen to exercise his broader authority under the state law to implement a regulation like that at the Lee Monument, and we'll see how it all shakes out. But I don't think anybody thinks there's a real or sustainable constitutional claim about that.
Claire, can you help me explore some ideas that I've had a tough time with myself, and that's understanding the extent to which the counter-protesters do not accept the ideal of free speech. Certainly not for offensive speech, or I should say certainly not for speech that they find offensive, that they have defined as hateful, as threatening. And so they want to shut it down. And we see that happening on college campuses with, loud students who are disruptive and bullying, and they shut down free speech events because they don't want to hear what the person has to say. This is, for example, a far-right person who comes on a college campus, and students will shut them down. That's happening all over the country. And we see that also in the public square. We see it sort of infiltrating our democracy as, let's just say, the radical left, Antifa. These are no friends of democracy. They do not believe in the ideal of free speech. They do not, in my view, they do not understand that a free speech right exists to protect those who specifically want to share hateful speech. I'm not talking about threatening violence, but I guess the key to understanding this is Antifa sees that speech as violence. They have defined this hateful speech as a kind of violence which should therefore be met with violence. Help us understand that from your view. Where is the ACLU on this, and how should we approach this?
Coy, you need to ask the proponents of that point of view to help you understand that point of view. I mean, obviously, there is what is called the European model, where there's very explicit content-based distinctions made about okay speech and bad speech. And that model is not the model that's reflected in our Constitution, in our view. We think that everyone's speech is safer when government isn't in charge of deciding who gets to speak. And, the First Amendment says government shall make no law abridging freedom of speech. It doesn't say any two private people can't have an agreement that one person's speech is unacceptable. But when you get into the business of authorizing government to make these choices, I mean, in the current environment, you're saying that you trust the, Sessions Department of Justice and the Trump administration to decide who gets to speak. And, in the next administration, maybe somebody different deciding who gets to speak. And, once you go down that route, all you have to do, I was looking the other day at the FBI's website on the hate crime statute. And there is a federal hate crime statute, and it says if you engage in certain conduct and it's motivated by racial animus, that you can be, prosecuted. But what's interesting about the FBI hate crimes website is that and I was looking specifically at domestic terrorism as well. If you look at their definition of domestic terrorism, it extends to extreme ideologies, and when you look at the 15 most wanted people on the domestic terrorism list, for the most part, let's see, there are 1, 2, 3, 4, 5, 6, 7, more than less than half of the people on this are white. Most of them are people of color. One of the white people on the FBI's most wanted list is a white woman who's a former member of the Black Panthers. Several of the other people have been on the most wanted list since the anti-war movement of the 70s, the white folks who are on this list, or they're environmental activists who have been defined as environmental terrorists. It is pretty clear who is seen as a terrorist and who's not. And domestic terrorism is not defined in a way that would consist by this government that would be coextensive with the kinds of views that you're suggesting are held by some people. So, I think we're all safer in the same way that if government has a religion, nobody has freedom of religion because you're then required to believe what the government believes. I think if government gets to decide who gets to speak, the person who's going to be told they can't speak is always whoever is in the minority voice at that particular point in time. And so I don't believe that giving government the right to define good speech and bad speech is the right way to go. And I think under our current Constitution, that would be unconstitutional.
And yet that is the perennial struggle. It would seem, especially these days, reminding the far right and the far left, hey, democracy is our ideal because democracy is under threat from both the Antifa and the alt-right.
Well, I think, if you look back at the most important and salient First Amendment cases that have been decided and the ones that are most protective of our rights, they involve people who at the time were a minority voice. That is, they were African Americans seeking civil rights, and were told that they couldn't, say those things. Those things were not acceptable. And they also involve other cases in which very unpopular voices, Nazis, Ku Klux Klan people, wanted the right to assemble or protest or parade or speak or, and the case law was built around them. But, there seem to be people who would like to change the Constitution, and they obviously have the right to advocate for that because we have a Constitution that gives them the right to advocate for that.
So, but How does that vast middle ground of Americans who still believe in the ideals of democracy, what should we do besides keeping our head down so we don't get caught in the crossfire?
Well, I think we just have to keep trying to educate people. I mean, we need to keep trying to have conversations, and we need to keep trying to talk these things through. I mean, obviously, I don't like Nazis. I don't like anything they say or stand for. I don't like white supremacy. I don't believe in white supremacists. But I know that eventually, if people, maybe I just have an optimistic view of the world, but I know eventually that the more we talk about how abhorrent their points of view are, a majority of Americans will come to consensus around the need to stand up against white supremacy, to stand up against Nazis, and not to allow them to become, the occupiers of the public square, or worse and more scary, the government.
Right, and giving the government the power to pick winners and losers in the marketplace of ideas. That's basically what we're talking about. And the far right and the far left are both lobbying for their own version of that kind of thing. And yet, as history has shown us over and over and over and over again, if you let power in any society decide ahead of time who are going to be the winners and losers, whether it's in the marketplace or the marketplace of ideas, or what speech is okay and what speech is not, you don't have freedom. And that ultimately is the goal here, as we have defined it, based on the foundational beliefs of our ideals. You knowingly and consciously forfeit your own freedom to accept those kind of limits on thinking and on speech.
Yeah, I mean, it's kind of the obverse of the golden rule. I mean, don't let government do to others what you don't want government to do to you. And obviously, there's a big difference between violent assembly and peaceable assembly, and we need to be clear about that. Obviously, there's a difference between speech and conduct, and where we have difficult conversations to try to figure out where the lines are is when is speech inciting conduct at a level that the speech itself is violent, and there are some times, and it's been recognized that there are some times when people can use what are called fighting words, although that case law is a little bit less robust than it used to be. But where if you stand in front of a building and say, "Okay, everybody, join me, and let's go attack the person whose office is on the 11th floor," that's probably speech that crosses the line. If you say, "Okay, everybody, join me, and let's take on the leader of a movement that's located 600 miles from the speech," well, that probably isn't that kind of speech. But some of those lines are hard to draw, and not being willing to continue to have the difficult conversations is a part of the problem.
You and I both have been engaged in this enterprise for many years, as you say, trying to have the difficult conversation. And it seems increasingly, thanks to social media, I would say, it becomes more and more difficult. You find more and more people who are engaged in these ideas, but they don't want to have the difficult conversations. They just want you to agree with them. As I put it, they are so warmed by the glow of their own political campfire that they really can't see and don't want to see past that. If you don't agree with them,
your words, Coy. Those aren't my words.
If you don't,
I mean, look. Yeah. When we started out, I mean, the ACLU nationally is almost 100 years old, and we're almost 50 years old. And one of the first things that the ACLU did nationally was stand up for Lillian Hellman, who was writing plays, and one of her plays had lesbian conduct, and the government wanted to censor it, and we said no. Because that was, at that time, an unacceptable and minority, idea. And the ACLU said absolutely not. We're going to stand with with Lillian Hellman and defend her right to put her play on in the public, in the public marketplace, in public. And when we at the ACLU of Virginia did the Loving versus Virginia case, I mean, deciding who you want to marry and being able to do so and live that love out loud, that's expressive activity too. I mean, it's not just conduct, it's expressive activity. But this affiliate in Virginia has one of our cooperating attorneys and former board members, David Baugh, argued a case in the United States Supreme Court on the right of Ku Klux Klan people to wear masks. And our national defended the right of Nazis to march through Skokie, although they never did. But the overwhelming majority of our work has been and continues to be on behalf of people who are the current minority voices in our society, and the 500,000 disenfranchised voters that we believe should have a right to vote, not a privilege to vote, not something somebody's going to be nice to them and give them a second chance about, but a right to vote that can't be taken away by government. And we're going to, when we're out there arguing with the Culpeper sheriff about his desire to have an agreement with the federal government where he volunteers to enforce immigration law that he doesn't otherwise have the authority to do. I mean, that's our work on a day-to-day basis. And the 4 days that we represented Mr. Kessler solely and exclusively to assure that the government lived up to the constitutional requirements is a very small fraction of what we do.
Claire, what's on your docket come January when the General Assembly convenes in just a few weeks in Richmond? What are you focused on? Is there one or two top things that your team is focused on?
Well, thank you. I mean, let's start with the right to vote. We are going to we're working with patrons to introduce a constitutional amendment that would say everybody 18 who's a resident of Virginia and a citizen of citizen has the right to vote, and that right cannot be abridged by law, which would repeal the current prohibitions on people who've been convicted of felonies and people who have been, quote, adjudicated to be incompetent from having the right to vote. As you well know, somebody might not be able to manage their checkbook, but that doesn't mean they don't have the competency to vote. And so we really do believe everybody who lives in Virginia, whether they're down the street or in prison, they should have the right to vote from the time they're 18, and nobody should be able to take it away. It's this fundamental currency of democracy, and it shouldn't be something that government can take out of your wallet or mortgage or tell you when you can have it back. And so we're going to work on that. We're going to, as a corollary or sort of a first step, we're going to work on repealing the excuse-based absentee voting system. We don't think one set of voters should be privileged over another, so everybody should have the right to vote in person or by mail absentee if they choose. They shouldn't have to put an excuse forward to the government in order to get an absentee ballot, and they particularly shouldn't have to do that when what they write down and put in the document is not private. It's subject to disclosure under the Freedom of Information Act. We're going to work on civil asset forfeiture. We think you should be convicted before somebody can take your property away. We're going to work on decriminalization of marijuana. We're going to be working on a new law that says that if police commit misconduct, they can have their what I call their license to police, their certification to be a law enforcement officer revoked Right now, it can only be revoked if they're convicted of a felony or certain misdemeanors. And we all know how often police people get convicted of any crime, no matter what the facts are or what kind of video is available. So we want them to be able to go through an administrative process and take away their ability to be a law enforcement officer by carrying a certification in the state. It's no different from lawyers. I mean, if I commit malpractice, if I violate the ethical standards, I can lose my license, and police people should be in the same situation. Those are kind of the big things that we'll be working on. And then there's and obviously we're going to resist any erosion of the right to an abortion, and we'll continue to work on a number of other issues by supporting our colleagues and allies like Equality Virginia and their fight for a true non-discrimination law for LGBTQ Virginians. We'll be supporting our allies who want to repeal the death penalty and seeking to make it clear that somebody who's seriously mentally ill should not be put to death. They can, whether they're convicted of the crime or not, once they get convicted, we don't think seriously mentally ill people ought to be executed. And we don't think anybody should be executed, but we definitely don't think we think there should be an exception that says specifically seriously mentally ill people can't be executed, in the same way that we have a rule that developmentally disabled people can't be executed. But we look forward to working with the new administration and the new legislature on a lot of things. That I don't know if you saw it, but Ken Cuccinelli and I did an op-ed where we both endorsed together raising the felony threshold above $200, not allowing civil asset forfeiture until after conviction of a crime. We also need to fix criminal discovery. Right now, you can be forced to negotiate a plea without ever seeing the evidence against you, which is crazy. He and I also agreed that there should be a statewide policy that no person should be asked their immigration status if they are a cooperating victim or witness to crime, unless it's directly relevant to the crime being investigated, like it's an international human trafficking case or something like that. And he and I agreed that it's time to return the State Corporation Commission to independence so they can actually protect consumers from exorbitant rate charges by monopoly utilities.
There's a lot of work to do, Claire.
There's lots we can do.
There's a lot of work to do. Hey, just out of curiosity, where are you getting the most pushback against the efforts to finally fix the right to vote in Virginia and to finally lose all of these Jim Crow era laws that are aimed at disenfranchising people of color, black men and women in Virginia? Who's still pushing back against that effort?
Well, I mean, the people who push back against it are the people who believe that they do better in elections if those folks can't vote. One of the fallacies there is that while 50 some odd, a majority of the people who are currently disenfranchised are people of color, the people whose right to vote is being restored right now are majority white because they're the ones who were convicted before the big increase in mass incarceration, and they're the ones who finished their terms, some years ago. But the right to vote is everybody's, and the only way we're going to purge racial injustice and bring racial justice to the ballot box, though, is by making it clear that it's a right that can't be taken away by government. Because, what happens is the people with power, the people in the government, make a decision about who they want to be able to vote, and so they have an excuse-based absentee ballot system that prefers, suburban professionals over people who have 3 jobs who live in the country. Because of the way it works and the excuses that they've drawn. And we just need to stop doing that stuff. I mean, we need to stop allowing the legislature to decide who gets to elect them. That's our right. That belongs to all of us. And all of us ought to stand up and say, it's not okay for government to decide who gets to elect them. We decide who is elected. And, when people ask me, aren't you worried about the fact that there'll be people in prison voting? Well, you know what? If you steal a $195 pair of tennis shoes in Virginia and you get convicted of a misdemeanor and you're sitting in the Richmond City Jail, you can vote absentee. You don't lose your right to vote. if you steal a $205 pair of tennis shoes and you get convicted of a felony and sent to a state penitentiary, you lose your right to vote for life unless a governor decides to be nice and give it back to you. I mean, really? We need to fix it, and we need everybody. You know, and the real sad thing is that people who don't want everybody to vote and don't want to make sure that access to the ballot box is equally available to everyone, I mean, they are the ones that run ads like we saw in this last campaign that says, you know, do you want a rapist on your jury? Well, you know what? Every good lawyer I know who knows how to do voir dire knows how to get people who might have a bias off the jury. And it doesn't matter whether their bias is because of their class and their, you know, experience as a rich person, or whether their bias comes from, you know, having been actually in the criminal justice system, you know, in the past. I mean, if somebody can't be objective in evaluating a case, then they're not going to be seated on a jury. I mean, it's just such a red herring, but it's, you know, kind of like the Willie Horton of today. It's like to scare people into thinking that there should be something wrong.
Yeah.
And the other piece is that, you know, people who care about the Second Amendment and gun rights ought to be working really hard to make sure the right to vote is everyone's, and to decouple their Second Amendment rights from voting rights and civil rights, because the process of when you should have your gun taken away should relate to how you used that gun and what wrong you did with that gun, and then you should get it back when you've shown that you've righted that wrong, you know, and paid whatever penalty for having used your gun poorly. It shouldn't depend on whether your right to vote is restored by the governor.
Claire, really quick before we run out of time, the latest round of elections, just let's talk politics for a second here. How does that impact your job to go after all of these goals to make democracy stronger, to strengthen the civil liberties of the citizen? The recent round of elections in Virginia, which saw a bit of a, a bit of a Democratic sweep, how does that impact your work?
Well, every single issue that I've worked on in the last 5.5 years at the ACLU required a bipartisan vote in order for it to move forward. There isn't any issue that I've worked on where one party or the other would decide whether we were successful. I'm going to give you an example. Civil asset forfeiture. Civil asset forfeiture passed the House, which was, you know, overwhelming majority Republican, with almost no dissent except from the Democrats. And then we got to the Senate side, and it got the rule that would say you have to convict somebody of a crime before you can seize their property, got sent to Senate Finance by two leading Democrats and hold up there because the Democratic administration didn't want to lose the $350,000 that was in the state police's budget that was based on their assumptions about what property they would seize and convert to the state police use in the future. And you know, so if we want to pass a law that says no person can lose their property unless they've been convicted of a crime, at least not lose their property to the state, then we're going to need Republicans and Democrats both. And that's not an unusual thing on the issues we work on, whether it's privacy and technology, warrant requirements for historical cell phone records, a lot of the criminal law reform stuff. Again, you know, if you look at the op-ed I wrote with Ken Cuccinelli, I mean, he's active in Right on Crime, and there are a number of Republicans that are more interested in making some of those criminal law reform changes than some of the people on the other side of the aisle. So I'm looking forward to a very interesting session where we make a whole bunch of new relationships, and where I'm hopeful we can put together bipartisan majorities in both houses to pass a number of things that we really care about.
Claire Gastanaga is the executive director of the American Civil Liberties Union of Virginia. You can find their latest work and support their work online at ACLUVA.org. Claire, thank you for your time and for all that you and your team do. We'll talk again soon. I really appreciate it.
Well, thanks, Coy. I really appreciate having the conversation and being able to answer your questions. And I hope that your audience learned something, and I invite anybody who wants to respond to do so in any way that they feel would be constructive.
You can follow the Twitter account of the ACLU of Virginia. It's at ACLUVA on Twitter.
You've been listening to the Citizens Band Radio Hour, a production of the Center for Media and Citizenship at the University of Virginia. Archived podcasts are available online at mediaandcitizenship.org. The executive producers for the program are Siva Vaidyanathan and Coy Barefoot.